ಶಿವಕುಮಾರ್ಗೆ ಇದು ಪರಶುರಾಮ್ ಇನ್ನ ಬೆಳಗ್ಗೆ ಹುಡ್ಕೋಬೇಕು ಅಸಹ್ಯ
ಶ್ರೀರಾಮ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಶ್ರೀರಾಮ್ ಜನರಲ್ ಇನ್ಶೂರೆನ್ಸ್ ಅಲ್ಲ, ಅದು ಇಯರ್ ಮಾಡಿ ಸೆಟ್ಲ್ ಆಗೋದು.
ಬಂದೆ
Sir, ಬರ್ತಿರೋದು madam.
Sufficient, sir. Memo for posting the emergency matter. They
What
consider
emergency?
it issues the petitioner warrant
When?
in family court in
Should.
tomorrow 27/6.
When was the order?
Order 24 7. Last month.
And today it is urgent. We will see.
Allow consider the memo.
Comply with the, if office of.
Already
Justice or
complained
comply,
last.
Tomorrow it will come.
If all of them.
Yes.
Already
If
complained
comply,
last.
Tomorrow it will come.
If all of them.
Yes.
I mentioned, my lord.
Out of the list,
My lord, serial number, list number 3, serial number 17, my lord.
serial wise she will call. Yes.
Page wise urgent.
Getting the interim stay order, my lord, I have filed an interim application, Dasra vacation application before the trial court. But in the last occasion, Honorable Court extend the interim order up to 2 months, my lord. That is required.
Probably you must have not been there in the court.
My lord.
There must be no representation in the
Please, my
court.
lord, I request
Then what to
this
do?
honorable- I am,
No, so why should we
no,
do it
I am
again?
filing vacating application before this.
You might, the convenience of the court, give some
Yeah, I
day.
have done tomorrow, my lord, please. Because
Tomorrow not possible. There are so many matters tomorrow I can't
Yeah,
take up.
tomorrow.
Basing on the convenience of the court, it will be
After
listed.
tomorrow, please, my lord. Yeah, because
We'll see. Yes, next.
application is started in 28th, my lord, this month, my lord. That is the reason which was pending.
When is 28th?
20th this month was started, my lord, Dasra vacation. That is-
No, why you are so sure that court is going to grant you visitation?
My lord, because earlier this honorable court has granted visitation rights. The petitioner herself has been vacated, so disobedience of this honorable court and the mediation center also
At
given.
least you didn't even choose to mention on the same day also that it should be taken up on so and so. You just keep quiet
No.
and happily come today morning and say, you pass some order, please take it up out of turn.
Sorry, my lord, because I came before this honorable.
We will
court.
see, we will see.
Wednesday, my lord, please,
We will see, yes.
please.
Page wise adjournment, page 1, list number 1, page number 2, serial number 6, page number 3, serial number 7 to 8, page number 4, serial number 9 to 11, 9 to 12,
My lord, serial number 12, madam, I am appearing for the appellant. My lord, kindly have it next week, my lord, on record counsel, Spurti Hegde is not feeling well. My lord. I have informed other side advocate also.
We represent every day.
Every day, my lord, but this is they have challenged the death of the deceased, my lord, Anga. Because of that reason, he will argue on that matter, my lord.
Compensation is not granted.
Compensation has granted, my lord, but insurance company has challenged the question of the death of the deceased, my lord. They have
Yes, this in the month of October.
Please, ma'am.
page number
Yes.
5, serial number 13 to 17, page number 6, 18 to 20, page number 7, 21 to 23, list number 2, page number 1, serial number 3, page number 2, serial number 4 to 9, page number 3, 10 to 15,
Your ladyship.
Till number 13, my senior's father's death anniversary will be taken up in this.
You represent the petitioner. Have informed the other side.
Chaudhary HR,
Please wait till they.
number 4, serial number 16 to 20,
My lord, serial number 17, my lords. There's some difficulty today, my lords. My senior is keeping a little unwell.
Yes, this in the month of October.
My
Lord,
lords,
serial number
serial
a date
number,
may be given, my
20.
lords.
page number 5,
October, we can't give the dates. Let it come in October.
My lord,
Lords, if
serial,
possible in September, a date. I apologize, my lords. There's some difficulty today, my
No, no,
lords.
what I tell you, it's an RPFC coming for the interim order. You please be here. Court will grant the interim order on some condition. Why do you want adjournment unnecessarily? Get instructions from your senior, how much the client is ready to pay. We'll grant interim order.
page
Yes.
page number 5,
my lord, serial number 20, my
Call
lord.
it 17,
20,
no adjournment, 17. Yes.
20, my lord.
serial
Yes.
number,
Appearing for respondent, I have informed the appellant and they are present, seeking an adjournment, your lord.
Okay, the request of the unconscious respondent. This is matter in the month of December.
page number 5, serial number 21, list number 3, page number 2, serial number 4, 5.
Serial number 5, my lordship. I am appearing for the petitioner, my lordship. The respondent herein filed 2 applications on Friday, my lordship. We
What
need
application?
1 week accommodation to file our statement of objections to the applications.
What applications? First of all, no, the matter is coming. You have an interim order. I'll on the merits of the matter, I'll hear these petitions. No objections. In an interlocutory application, they're filing objections. No objections. In an interlocutory application, they're filing objections. For that, you filing your
Lordship,
objections.
they filed IA for vacating of interim order.
It has to be vacated. It has to be disposed of. Whether they file application or not, I would have heard this matter today. So please don't ask for time. Yes.
Page number 3,
Huh? Huh? Why?
Sayyid Khalil Pasha.
Coming up for preliminary hearing. This also in the month of December.
Page number 3, serial number 12 to serial number 19.
My lord, serial number 17, my lord.
Matter may be referred to the local, the mediation center.
He is not the counsel for in our matter.
19.
19.
Both of you are there.
At least
Mohan BK.
Serial number 17, my lord.
Huh?
Which Bangalore or it is submitted, the matter may be referred to the Bangalore mediation center. At the request of parties, please, the party shall appear before the mediation center on 24th of September. 25th. It's what is your matter, Mr. Bharat?
My lord, serial number 17, my lord.
Hmm.
It is listed for the petitioner to submit the statement of assets and liability. I am for the respondent. I am seeking short adjournment.
If
As
he
the
has
organ-
not filed, why do you want adjournment? If he has not filed, it will be heard based on, considering that we'll take an adverse inference. For that, adjournment is not required. Yes, next.
Page, list number 4,
Obligation.
list number 3, serial number, page number 4, serial number 29, 20 to 22. List number 4 for referring Lok Adalat matters. Serial number 1 for furnishing of process to issue notice to all.
No, take that. Take the file.
If your lordships permit me, there's 1 matter in the second list, my lord. That matter was disposed of on 31st of July. Your lordship was pleased to remand the matter back to the trial court. Second list, first matter, my lord. There is a small typographical error, my
We
lord.
will see, not now. When the list, when that matter we call, we will see that.
It's only adjournment purpose
Oh,
for being spoken.
Karnataka, what is this? KGID.
Anyway,
Who appears for this? The government advocate. For R2 also. Refer all these matters to Lok Adalat. Yes, call the list.
number 1.
What is this list? Matters pertaining to Sriram Janvi. Yes, first. Yes.
Number 1.
Yeah, for appellant.
Serial number 1.
Yes, for death man.
Milord,
Adishati.
Why is it
case,
adjourned
Milord,
at that
on
date?
behalf of Mr. Pradeep Milord, R2, it appears, Milord, in this case, this case is by the owner. And there are a series of cases, Milord, where it is, Milord, implemented. So he wants to find out, and a copy of the DL also is furnished to Mr. Pradeep Milord. He has sent it for verification because probably the liability will go on his insurance company.
At the
Milord,
request of London Council for the insurance company. When 1 week?
Milord.
1 week?
R2, Milord.
1 week.
No,
1 week. 1 week is
This
sufficient.
is matter. Next week, give a date.
25 days.
Yes, next.
For dismissal, serial number 2. Nagaraja Reddy.
I couldn't represent. Lord's case of injury, lords, are dismissed by the trial court.
Yes.
On the ground, lord, delay of 7 days in filing the complaint, lord, and
Let's see.
the vehicle. Yes, my lords.
Date of accident,
15/3/2018.
15/3/2018.
complaint.
23/3/2018.
What are the injuries?
Right foot not open, laceration, dislocation of second, third, pterygonomal joint, plantar dislocation, and other. He was in hospital.
MLC is filed.
Yes, my lords. MLC is not filed.
Then he must have been admitted in the hospital immediately.
Yes, my lords. He was
What
admitted.
are the documents? FIR, complaint, Mahajar, Caesar, wound certificate,
Yes.
exhibit P5. You have a give that P5?
That is the reason why the tribunal has dismissed the claim petition.
Because mere delay in giving the complaint can't be a reason.
Apart from that, your lordship, I'll get it.
So it says, if you look at the exhibit P5, P5 says,
I don't have the copy.
16/3/2018, said to have been caused on 15/3/2018 due to alleged history of road traffic accident. The injury is sustained or grievous in nature.
On 15th itself, my lords.
My lord, I will request your lordship to kindly the finding of the tribunal. It starts from para 10. It has been elaborately discussed.
Have you seen this?
Yeah, I've seen that.
Let's see.
Paragraph number 10, page number 5.
Yes.
Shall I read, my lord?
Yes.
At this juncture, the other materials available on record and the oral evidence are looked into. On going through the documents, it is seen that on 23/3/2018, a written complaint was lodged by the petitioner sister by name Bhagyamma, stating that on 15/3/2018, after about 7:45 p.m., when she was in her house, she received an information through phone that her brother has met with an accident. The accident has taken by...
You can straight away come to 12. You can come to paragraph 12.
In this background, now I would like to further appreciate the oral and the documentary evidence available on record. From the pleadings and the recital of the exhibit P2, it is forthcoming that soon after the accident, petitioner was rushed to Chetana clinic, in front of which the incident happened. On the very same day, the complainant, who is none other than the petitioner's sister, had been to the hospital. She said that in the complaint that on inquiry made with so-and-so, Tata AS number so-and-so. As to from FIR, the so-and-so, the station is around 0.5 kilometers. So she could have given the complaint on the very same day against the driver of that vehicle, on coming to know that it is so-and-so. The medical legal case, definitely the medical legal case will have been registered. MLC intimation will have to be sent to the police station from the hospital authority. It has come in the petitioner's evidence that the police have come to the hospital, the accident spot, and even the hospital for when taking the treatment. Under the circumstances, either the petitioner could have given the statement to the police, then the police themselves should have recorded the statement about the accident. But neither of them did exercise the due diligence which they were expected to do in this regard. Why the petitioner could not give his statement is not explained. Likewise, why the police have failed to record the petitioner's statement in the hospital.
What are the vehicles involved?
Tata Ace,
Tata Ace and two-wheeler.
How and whom the accident was caused?
Very meticulously, technically dealt with it. We'll set aside this order. Demand it, let them produce the MLC. Agreed with the award passed in MAC number 2390/2018. Agreed with the dismissal of MAC number 2390/2018 dated 13 July 2020. The appellant claimant is before this court. The claim petition is filed seeking compensation for the injuries sustained by the claimant in the road traffic accident. It's a case of the claimant that on 15/3/2018, the claimant was riding his motorcycle. It's a case of the claimant that on 15/3/2018, the claimant was riding his motorcycle on the left side of the road at about 7:30 p.m. when he reached near Chetana Clinic. The driver of the Tata Ace suddenly took turn without giving any signal and hit the motorcycle. Due to the impact, the claimant fell down and sustained severe injuries. His motorcycle was also damaged extensively. Soon after the incident, he was taken to the nearby Chetna clinic, wherein the first aid treatment was given. From there, he was shifted to Someshwara Hospital, in which he was treated as inpatient and surgery was done. The tribunal had dismissed the claim petition on the ground that just a few ads from the hospital. And further, in the Moon certificate, it's shown as road traffic accident, whereas in the discharge summary, it is shown as a road traffic accident between a two-wheeler and an auto. The vehicle that is involved in this accident is Tata Ace, and the court has come to the conclusion that there is a difference between an auto and a Tata Ace vehicle. Further, MLC is an important document which has been withheld by the claimant. Hence, an adverse inference has to be drawn and accordingly dismiss the petition. Next para. When counsel appearing for the appellant claimant submits that in fact the doctor was examined. Yes, it stated that there is an MLC, and if necessary, you would produce the same. It is submitted that all other the evidence on record, the Moon certificate, and other documents are in support of the case of the claimant. Mere delay in giving the complaint cannot be a reason for the court to dismiss the petition. It is submitted that the court had dealt with the matter in a very hyper-technical manner and dismissed the petition. It is submitted that the matter is remanded and an opportunity is given. They would be filing the MLC register before the court. They will place the same before the court. Next para. When counsel appearing for the place the same before the court. Next para. When counsel appearing for the respondent insurance company submits that court has rightly discussed evidence on record, and he has drawn the attention of the court to the particular paragraphs wherein the court had held that the claimant, the delay in giving the complaint and also not placing the MLC register is fatal to the case of the claimant. It is submitted that the court had rightly dealt with and rightly dismissed the claim petition. There are no grounds to interfere. Next para. Having heard the counsel so and so. The wound certificate, the discharge summary supports this case, and the mere delay cannot be a ground. There is no dispute about the fact that in each and every case, mere delay in giving the complaint itself cannot be a ground for the court. This is the petition. However, that depends upon the facts and circumstances of each case. Coming to the facts of this case, when it is a road traffic accident, MLC is a crucial document. According to the doctor and according to the petitioner, MLC is available, but admittedly, the document is not filed before the court, and basing on that, court had dismissed the petition. This court, balancing the interests of the parties and in interest of justice, deems it appropriate to set aside this order, remand this matter to the trial court, only for the purpose of filing the MLC register before the court, and the court shall consider the same and pass appropriate. On compensation, any exercise is done?
No, my lords.
Then not on that particularly, because it is remanded and the appellant, both the parties are at liberty to adduce evidence, and without further notice, the party shall appear before the court on 12th of October, and within 6 months from thereon, the court shall dispose of the matter. The court shall dispose of the matter.
Serial number for orders matter,
Correct.
serial number 3. Serial number 3. Mahadev
Appear for
Swami,
respondent.
Memo is filed seeking dispensation of notice to R1 dispense with the risk of appellant. Yes.
The
Case of death and for enhancement could be disposed.
The case of death, the deceased is
What is the age?
48 years, working as a driver.
Court has taken the income at
12,500, 12,500.
which year is the accident?
2018,
How much should be taken?
correct. Adalat income was considered, my lord, but he is a skilled.
Driver cab license, my lord, in 2000 itself, 8 years prior to the accident.
So how much can be
You're
taken?
From 15,000.
How many are the claimants?
The claimant is the wife and son, my lord.
1/3.
1/3.
Court has deducted 1/3.
Yes, my lord.
25. Future
25% for future.
Taken?
15% as considered, my lord, trial court.
Yes. What is the multiplier?
13, my lord.
It's coming to 18,16,000. What is awarded?
15,64,948.
It is before this court seeking enhancement of the compensation. Then counsel appearing for the claimant submits that the claimant that submits that the deceased was a skilled, he was a driver. He was having a cab driving license right from the year 2000.
2018.
2000, my lord.
2000. Accident is in
2018, my lord.
From 2000, and the accident had taken place in the year 2018. Even for skilled labor, court had taken 12,500 as the income. It is submitted that as he is aged 48 years, court ought to have granted 25% future prospects, but only 15% future prospects were granted. It is submitted that the compensation that is awarded by the tribunal is on the lower side. Next paragraph. Land counsel appearing for the respondent insurance company submits that the tribunal had rightly granted the compensation and there are no grounds to interfere. Next paragraph. Having heard the counsels on either side, there is a material on record. The tribunal had granted the compensation as per the table given below. Table is at paragraph number 26 extract. The court had taken the income at 12,500, considering the fact that he is a driver. He's having a cab driver's license right from the year 2000. This court deems it appropriate to take the income at 15,000. And as considering his age 48 years, future prospects would come to at 25% would come to 3,750. That is 18,750. And there are two claimants. The 1/3 has to be deducted towards the personal expenses. That is 6,250. And the same is deducted. His contribution would come to 12,500 into 12 into 13 is 19,50,000. Loss of consortium 88,000. Funeral expenses 36,000. In the light of the law laid down in Make House 948 to 18,16,000, the enhanced amount shall carry 6% interest. Yes. Next.
Cell number 4, Satish HK.
Yes.
For appellant.
Memo is filed. Memo for acceptance of paper publication. Same accepted. Notice to R1 is held sufficient. Yes. Are you ready?
No, my lord. Press which time, my lord? They have not filed.
I appear on behalf of Janardhan Reddy. He raised time to file wakalat and
Admit, course of final hearing, call for the DCR.
Till number 5.
I think there is a delay that we will condone.
please go.
In that IA number 1 of 22 is filed to condone the delay of 117 days. For the reasons stated, the delay is condoned on the condition that he will not be entitled for interest for the delayed period. Yes, next.
Till number 5. Pramodar. No further.
Second respondent,
This is a case of injury, my lord.
only
The
quantum.
The date of accident is, my lord,
Please
27.
come to the table straight away. Table.
Table. 19, my lord. Page 19 of page 5.
What are the injuries?
Compound fracture,
Hmm.
both bone fracture.
How
Date
many
of-
fractures?
2 fractures, my lord.
Hmm?
2 fractures. Fracture
Date of accident 2007, 27,
Then
4,
how many fractures?
2 fractures.
2 fractures.
operated, my lord.
Hmm. Then we will grant 50,000 for pain and suffering.
Pain and suffering, 50,000.
Medical expenses? No.
Medical
No
expense,
medical
he has
expenses,
taken, he has taken treatment in the government hospital, my lord. There is
Hmm.
no- Towards food and nourishment, my lord,
1 minute, look at the table.
that is
As per that, you please make your submissions. How many days was in hospital?
24 days, my lord.
Huh?
24 days.
But he is not produced the document, medical documents and.
What is the discretion of the court while granting 10,000? 24,000. Then loss of future earning capacity.
The income was taken as 10,500. Accident is of the year 2017.
Court has taken
Whole body disability.
17 by, and what is a full body disability?
17%.
17%.
I mean, limb disability.
Limb disability 54%.
Huh?
54%.
Is correct here.
It's coming to 2,80,500. Then loss of amenities. How much is granted?
15,000 is
15,000.
granted.
Another 10,000 will grant. Then loss of income during laid up period.
That is 12,500 into 3 months will be taken. It was taken for 2 months. Maybe taken for 3 months.
So it's 12,500 into 4. It comes to 50,000. What is this future medical expenses? 5,000? You don't have, no.
He is not produced the medical.
When you have not spent medical expenses,
Surgery was done.
same.
I don't.
So we will not take that 5,000 also will not grant.
No future medical.
Legal expenses 10,000. It's coming to 4,39,500 against 3,06,620. Yes, please come. Agreed by the award passed on MVC number 354 of 2018, dated 23rd May 2022, whereby the tribunal had granted 3,06,620 as compensation. The claimant is before this court. In the year 2017,
2018, my lord.
2018, court had taken the income at 10,500. Court ought to have taken the income at 12,500. It is submitted that under the head of pain and suffering and loss of amenities, the amount that is granted by the tribunal is on the lower side and that needs to be enhanced. Next para. Land counsel appearing for the respondent insurance companies of this. The court had granted a just and reasonable compensation and there are no grounds to interfere. Next para. Having heard so and so, so and so. The claimant had sustained 2 fracture injuries. Hence, under the head of pain and suffering, this court is granting 50,000. Coming to the diet, food and nourishment, he was in hospital for 24 days and the court had granted 10,000 and this court is granting 24,000. Coming to the loss of future earning, as this accident is of the year 2018, this court is taking the income as per the table at 12,500 into 12, into 11, into 17 by 100, is 2,80,500. Coming to the loss of amenities, considering the disability of 17%, this court is granting 25,000. Then coming to the loss of income during the later period, he was in hospital for 24 days. Hence, for 4 months, 12,500 into 4, 50,000. In the light of the law laid down in make allowances so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,39,500. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,06,620 to 4,39,000.
90 days delay.
Huh? Delay.
Delay.
It
not
is
carrying.
connoted on condition.
No interest, sir. Regarding delay.
Below 100, there no such clause.
My lord, my
Sir.
request, sir. The HCR may kindly be ordered to be sent.
It will be done. Where do you get the delay? In this manner. It's a docket order. I number 1 of 22 is filed to condone the delay of 90 days. Delay is condoned, no condition, only after 100. Yes.
Sir, may kindly be ordered to send.
Huh?
Urgency is there for LCR.
Everything will go.
Because the claimant is suffering from the.
Huh?
Claimant is suffering from the.
Conditions would be send the TCR along with the copy of the order. Yes. See, in everything like you have a format, you will get everything in that. Yes, next.
Interlock to the application, sale number 6. Kumara
In
KG.
this, next matter
Appearing for
6,
the respondent.
I number 1 of 19 to condone the delay of 80 days. The reason stated, delay is condoned. Yes.
I'm
Who
appearing
appears?
for-
Where is Mr. Kumar KG?
Kumara KG.
You are representing Ashok and Patel.
Yes, my lord. My lord, one more connected matter is their owner has filed.
Yes. Admit, post for final hearing, call for the TCR, post along with right
It
on
is
the
already
paper and-
posted, my lord. It is already posted, my lord.
Oh, 6.1 is there. Then don't pass this final hearing. Then in 6.1, who is
R1.
R1 is who? Claimant. Take that file.
I
Who is
don't have a
R1 in
petition. my
6.1?
lord. I don't have a petition because I am not served on that.
Let us see. The second appeal is by the owner.
Yes, my lord.
Insurance company is appearing. R1 must be the claimant. Their claimant's appeal is here.
The claimant's appeal is for the enhancement, my lord.
That I understand. Look at it. Is easy the claimant?
Rudrama is the claimant.
Yes, ma'am.
The second appeal.
Yes.
Kumara KG.
Mr. Kumar KG is directed to take notice on behalf of the claimant. Land counsel for the appellant shall serve the copy of the appeal memo. Now we can say admit post for final hearing, copy of the appeal memo. Now we can say admit post for final hearing, call for the TCR. Yes, next.
Sale number 7. Sale number 7, Shantraj K. Syed Abdul Sabut.
Where is Mr. Shantraj?
C.R. Ravishankar.
I'm contesting from the owner side, my lord, owner and driver. And actually, because the tribunal has awarded against me for not ex parte, I have not produced before the appear before the tribunal. So that is why I came before this honorable court for.
Where is Mr. Ravishankar?
It's already 2018 matter, my lord. I have
Maybe passed over
deposited.
21. My lord, what happened, my lord? I did not note my appeal, my lord. And MFA 115820 came to be disposed of, my lord. And I got it recalled. It is enhanced, my lord, after hearing both the sides. I'll just make submission, my lord, in my case. And can I request your lordship to retain the same amount, my lord, 5,41,000.
Where is inform them, pass over this also.
My lord, in my case, my lord, I only said that the width of the road, I think your lordship may not accept it, my lord. I said that the width of the road is 19 feet and he had sufficient.
Let her. Yes, sir. Pass over. This next.
Sale number 9. Sale number 9. Ines but for appellant.
Yes, admit post for final hearing, call for the TCR. Next 10.
Sale number 10.
10 will not, even the insurance company has filed MFA 1981 of 22.
List
I've
along
given
with
the
the-
number, my lord. Given.
Write it on a paper. List along with so and so. Give a date.
My lord,
Yes.
one submission.
25-9.
Actually,
1981 of 22.
It is my appeal.
Slip is
We have got jointly submitted before the Lokadala. And it has been again returned back, saying that it has been, they have filed the.
my lord,
I'm not referring it to the Lokadala
Yeah.
thing. I'm saying give a date along with their appeal.
and the party is present, my lord, he is having severe disability, my lord. Even he is not able to walk. For that purpose, I have brought it personally. Even additional medical expenses is there.
That is for Renuka to say. Yes, next.
25-9. Cell number 11, Geeta,
I appear for respond number 1.
Where is Geeta?
Sivakumarappa,
For appellant, my lords. Insurance company appeal. Accident occurred on 14/5/2017, my lords. The claimant was proceeding as a pillion rider on a motorcycle. My lords, the accident occurred because the motorcycle went and hit the rear side portion of the track. Were not arrayed as a party before the tribunal. The entire liability has been fastened on me. It's my contention that the accident occurred on account of composite negligence on the part of the rider as well as the driver of the tractor, my lords. But the entire liability is fastened on me just for the reason that the claimant did not choose to array the insurer and the owner of the motorcycle, my lords. That's the only ground.
Who is injured?
Pillion rider is injured. The accident occurred in a daylight at about 8:45 a.m. in the morning. It is not a tractor with a trailer. It is a tractor alone. Tractor was proceeding ahead, and motorcycle, he goes and hits the rear side portion of the tractor. But still, the tractor, for the best known reason, driver of the tractor was also made as arrayed as a accused driver in the charge sheet for the rash and negligent driving. My lords, kindly exhibit P9 may be looked into, my lords.
Please come to the.
Exhibit P9 may be looked into, my lords.
Please come to the calculation.
My lords.
Come to the calculation. Are you questioning? I mean, anything on the maintenance? I mean, the compensation?
No, my lords. My ground
is on that.
The ground is
So
on that.
it should have been even the liability should have been on the
Yes,
owner
my
of the
lords.
motorcycle. Yes.
Even as per going by the Kaini judgment and Ganesh judgment rendered by this honorable court, the finding is, if in such a situation, an observation is made, giving a liberty to the insurer or the person who is held liable to recover the 50%. This matter I seek a week's time, my lords.
Already it's adjourned. Somebody asked in the morning.
Yes, my lords.
Yes, next. 13.
12, okay.
13.
Cell number 13. Cell number 13, Pradeep D, for appellant,
For the appellant is
Vijay Kumar T.
respond.
IA number in MFA 8690, IA number 2 of 23, 211 days, same, on condition. Yes.
So far as loss of future earnings, my lordship, last occasion.
It's only on quantum?
Only quantum. Because,
Please come to the table.
Please.
Oh, it is in Kannada. Anyhow. Which year is the accident?
Before that, my lord, loss of future earning is concerned, my lordship, last occasion I addressed the argument. The 2018-19 is the accident. He has paid the income tax returns 1,40,350.
With regard to the enhancement,
The cross examination also, the petitioner admitted that has been increased.
Even though
Other rates, my lordship may grant
continuing in the same job, my lord, and even though continuing in the same job and getting same
that's
income.
what I'm saying. It is on loss of amenities. We will grant the compensation. That's what I'm saying. It is on loss of amenities. We will grant the compensation considering the disability on loss of amenities, not on loss of future earning.
Please, my lord, he has to suffer through
Hospital.
4 days.
4 days, my lord.
Hospital.
4 days.
4 days, my lord.
Recorded.
10,000.
10,000. Anyhow, we will continue that. Then Loss of immunities, for 7%, how much we can grant?
Loss of amenities, 10,000. Loss of amenities only 10,000, madam.
What do you say, Pradeep, on loss of immunities?
Lordship could have grant 50,000.
Last occasion also your lordship said 50,000 will be given.
50,000 only, I am telling.
50,000 only?
I am written here, that's
Loss
what.
of amenities also, my lord.
No,
Yes,
I
loss
am
of
on
amenities
loss of
only.
immunities.
Loss of amenities only.
Already pain and suffering 50,000 is
50.
over.
Loss
Granted
of amenities
already.
50, pain and suffering 50. Last occasion, my lordship has suggested. 10,000.
7% will not grant 50% generally. On other heads, we are not granting on for, we will make it 70,000. Because the future loss of earning, we are not, it is 4 lakh.
There is no surgery, that's why. Otherwise, I would have submitted that, my lordship.
Passed by the tribunal, whereby the tribunal had granted an amount of rupees 5,41,714. Both the claimant as well as the insurance company are before this court, questioning the quantum. The tribunal had granted the compensation as per the table given below, that is at paragraph number 38. Land counsel appearing for the insurance company submits that the tribunal had granted an amount of rupees 4,28,400 on the ground under the head of loss of future income. It is submitted that the claimant, there is no loss of future income to the claimant. He has placed the income tax returns before the court. For the financial year 2018-19, his income is 1,40,355. The financial year 2020-2021, it is 4,19,000.
4,06,000.
4,06,000.
1920.
1920. It is not 2021, it is 1920. 1920. It is 4,06,000.
6,000.
6,000. It is submitted that there is a considerable income in the, there is considerable increase in the income of the claimant. Hence, he is not entitled for any, you're not entitled for compensation on the head of that. There is no future loss of income because of the injuries sustained by the claimant in the accident. Hence, he is not entitled for any amount under the said head. Then coming to the pain and suffering, and coming to the medical expenses, basing on evidence court had rightly granted, no interference is called for. Coming to pain and suffering,
My submission also recorded.
Madida. His submission has to be noticed by lordship, like this.
For which submission?
His submission is the compensation has to be granted more on the other rates, like.
So,
ಹೇಳಿದೆ.
I already recorded that. You said only on future income court has rightly granted. On other heads, it has to be increased. That's what I recorded. What is that? Coming to the pain and suffering, considering the two injuries that are sustained by the grievous injuries sustained by the claimant, this court is awarding 50,000. Coming to the transportation, diet and nourishment, court had rightly granted the amount and no interference is called for. Coming to the loss of amenities, this court is granting 50,000, considering the fact that no amount is granted under the head of loss of future income. In the light of the law laid down in Meghalaya, so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 2,03,314. Claimant's appeal is MFA number 869 that year in the starting, and the insurance company's appeal is so.
Question number 14.
Yes. What is that? If any amount, if excess deposited, the insurance company is at liberty to withdraw. Yes, that earlier matter, 11th. What is that? 24. Yes, next.
Question number 14. Finally, hearing last Shashidhara for appellant. Naveed
Appellant.
Benny.
For second respondent, please. Yes.
Table.
Please. Page number, para 12, my lords, issue number 3, page number 15. But in this case,
No
the
table.
petitioner that she was wherein
What is this table? Due to disability, medical expenses, food nourishment.
they are not given.
So, what are the injuries?
Is fracture of neck. Doctor has assessed 28% disability.
To the limb.
Limb.
So
And-
now pain and suffering will grant 40,000.
Yes.
No medical expenses.
Medical expenses are produced. 43,500 is the bills.
Why it
Produced.
was not considered?
That is given.
Where do you get have to consider like?
No, my lords, after 14 years, my lords, promotional income has to be considered as per the division bench of this honorable court judgment. For him.
No, division bench of this honorable court can't be contrary to the judgment of the
No,
Supreme
my lords,
Court.
that in Mallikarjuna's case is less than 10 years, my lords.
Is it so?
12 years, yes.
Take the judgment. Let's see.
My lord, in this case,
Is it that it is
No,
less
no,
than 10 years?
I have not gone through the judgment, not furnished. But my lord, last week also followed the Supreme Court judgment regarding the minor case. I mean, this by law.
Let's see. Taking that it is-
Mallikarjuna case is pertains to child, my lord, children. But in this case, this honorable court in division bench has
14
considered,
years is not a child.
yes, my lords, after 14 years, so 12 years.
Huh?
12 years, up to 12 years, my lord, up to 13 years is considered a child. From the beginning of 14 year, my lord, as per the
Purpose of 8 years ಇದರಲ್ಲಿ 9 is important 15 purpose of explaining ಇದೆಲ್ಲ ರಿಲೇಷನ್ಸ್ ಇದೆ
Where do you get that?
from para 8, my lord, 9.
9 ಅನ್ನೋಸ್ my lord important
On the aspect of monthly income of the minor appellant, we are inclined to refer to the with the judgment. Yes.
15 important
It is not a case of
Para
death.
15,
This is not a case of death.
case of injury
injury.
It's a case of injury.
This is also case of injury.
No, no. Please read paragraph number 9.
Para
9 of the judgment of the Supreme Court, which you are referring.
on the aspect of monthly income of minor appellant, we are inclined to interfere with the judgment and order of the court below. In the present case, it is evident that the courts below have failed to take into account the monthly income of the appellant while determining the quantum of compensation. It is now a well entrenched and consistently reiterated principle of law that a minor child who suffers death or permanent disability in a motor vehicle accident cannot be placed in the same category as a non-earning individual for the person not engaged in gainful employment at the time of accident. Such a case, computation of
The whole
compensation.
difficulty is, Renuka, the whole difficulty is there is lot of confusion. Which judgment to apply? No, they refer to Kajal's case.
My lord, if this principle is to be applied, my lord, the court
No, no,
itself, there's a
Kajal's
child
case.
labor.
Huh?
My lord, the child labor is prohibited, my lord. And here if they come to the conclusion that at the age of 14.
No, that apart, the Supreme Court judgment also, they refer to Kajal's case. Kajal's case is a case where they have taken into consideration that the notional income and all, considering the plight of the child who is completely paralyzed. Now, Mallikarjun's case, where is it going?
Lord, regarding para 15 announced my lord detail has been discussed
The consistency in the judgment. Like every day we can't do one something. No, if not today, till yesterday we are applying Mallikarjun. Today suddenly this judgment. Now what is injustice to them? What the courts have done?
case and
16 needs to be done.
Mallikarjun case also discussed my lord
Huh?
in this case in this judgment my lord Kajal case and Mallikarjun case my lord Kajal case and Mallikarjun case also discussed my lord.
Where is discussed? It is only Kajal's case that is discussed. Any of Kajal's case?
Para 6.
Para 6 my lord
No,
is referred.
Kajal's case cannot be applied to every case.
Yes,
Because it is para?
Para 6 and
Mallikarjun case is
Referred in para
referred,
6.
my lord, para 6.
Uh,
And in para 9, my lord, Kajal case is referred.
No, it only says it is referred as, it says High Court has considered this. Apex Court has not,
discussed.
distinguished or adverting to the fact that the appellant was an 8-year-old child at the time of accident. Now, in this case, he is 80-year-old. You are saying that when it is 14-year-old, something else will apply.